Okay, so now let me check this side. Okay. All right. So today we have Miss Phyllis Hughes with us, and she is my special guest on today. She's someone that have been through the probate process, and I'm delighted that she decided to come on and share her experience with us. So before we start, I first want to say a happy New Year's to everybody. I hope you had a blessed New Year's and a blessed Christmas. I hope everything went well for you and your family. And we're just going to jump right into it because I know a lot of people go through probate, people experience different things in different ways. So I thought it would be helpful to bring Phyllis on so she could share her journey, her roadblocks, the things that, she had to do and what she learned, and maybe it'll help somebody else along the way. So if you're watching this, feel free to chime in if you have any questions, and hopefully we can get them answered for you. So, Phyllis, I'm gonna let you introduce yourself, and then you can just tell us about, your experience with the probate process.
Okay. Thanks, Denise, for having me on. Over the last several months, I've tried to connect to the Facebook site and provide as much input as I can. So some of you all may be familiar with some of my postings, but I thought, it might be a good idea to share some of my experiences. And so one of the things that I want to say first of all is that the probate process is not for the faint at heart. And so one of the things that I've learned is that just for me personally, from the whole going through the process, is that as it relates to my own personal situation, for me, I'm going to make sure that I do some good estate planning, because the probate process, in going through the process, I really felt like it's really not designed to be helpful. It felt like there were roadblocks in every direction as you were going through it, and you really have to know a lot about the intent of the law and not just what's on the forms. And so one of the I will say that one of the benefits that I had is when going through this probate process, it was to probate the property for my stepdad. And one of the benefits that I had in going into the process is that I also had to do many years ago. I had to probate my biological dad's property. And one of the things that I learned through that process was that hiring an attorney is not always the answer. You spend there. I'm come to believe there are not a lot of attorneys that really even understand the probate process any more than we do. And so many years ago, when I had to go through the probate process of my biological father, my sister and I actually hired an attorney, and we spent more time chasing down that attorney and trying to get the attorney to do what they were supposed to do and be timely and so forth. And so this time, when we were faced with my stepdad's death, I decided we were going to try to go this alone. So so I will just tell you a little bit about my personal situation with my stepdad. He was My mother died in 2019, and my stepfather remained in the home from 2019 until late uh, 2020, 2022, and then he was suffering from dementia, and we had to basically move him in an assisted living, and there was a whole series of events that occurred, and but he passed away in May of 2023. And so before, when he was getting ill, and realized that things were going downhill, he did set up his bank accounts jointly with me, and so that made things a little bit easier for me to manage as we were going through the probate process. But but basically, he died in May of 2023, and I was listed on his will as his executor. Well, that was the first stumbling block, because when he executed the will, it was not notarized. It was actually signed by bank employees, but they did not notarize the will. And so when I took the will to the Cumberland County probate office, they would not accept the will as a valid will for purposes of executing the probate process. And I was initially really concerned because when I went to the probate office and they wouldn't accept it, um, I I thought that I had 60 days from the date of his death in order to start the probate process, because that's what, when you read, that's what it tells you. But when I got to the probate office, they told me no, that was not the case, and that there were some people who actually never um, went through the probate process. So I did at that point. I really didn't know what to do, and I was not, wasn't a valid will. I didn't know, how we were going to get it probated. So um, I have uh, my brother and I share, with my stepfather is my brother's biological father. So I contacted him and asked him if he could be a co-executor. Um, through the probate process, which he actually did. He lived in Charlotte. I lived in Calabash. My dad lived in Fayetteville. So basically, that's what we did. We decided to be co-administrators, and we actually went to the probate office together to file for the letters of administration. And for those of you who are just starting, the form for the letters of administration is at AOC E 202. That's the form number. And that in with that form is also a preliminary inventory. So basically, when you go in to file for the letters of administration, you have to have a general idea of what property the deceased has. And so you're going to be asked from a preliminary standpoint to list any bank accounts, any personal property, any real estate. That, of course, doesn't have to be etched in stone. It doesn't even have to be, really correct, because I guess there's an understanding that at first you really don't know, until you go through the house or go through their belongings. You really don't know exactly what you're going to find. So that's what we did. We filled out the application for the letters of administration, and listed the preliminary inventory, what we thought um, was available in bank accounts and cash and all that. And that day we were actually sworn in and given the letters of administration. And if I'm not mistaken, we had to actually um, pay a filing fee. That wasn't a lot. We had to pay a filing fee. And and then we were issued the letters of administration, and that gave us the ability to proceed on with with business. So as soon as we got the letters of administration, my brother and I went directly to the bank and opened up an estate account, and so that we could then start to operate. Now, one of the things that's interesting when you look at the timeline is you have, within a certain period of time, in order to to the come back to the probate office to file the second inventory, which is technically the final inventory. And in addition to filing that, you have to also be able to present to the probate office um, any debts and settlements of any debts that you are aware of. And in order to do that, you have to then put out um, a notice to creditors. And so, it's a really tight timeline, because you have to give the creditors so much time. It's like basically a 3-month process when you have to report back to the court, and you have to give the creditors so much time to respond to you. So we literally, within maybe a week after we left the probate office and established the estate account at the bank, we literally issued the notice to the creditors. And there's a form that they give you that you will have to fill out when you return. And so basically, what you have to do is you have to advertise in the newspaper um, for a full month, every week for a full month, 4 times, and you have to give the creditors so much time to respond to your notice to creditors. And then if you have any known creditors, and in our particular case, we did know that my dad still had a mortgage on the house. We knew that. And so, if you have any known creditors, you're supposed to send them a letter stating that you know that they're a creditor, and that explain to them how you're going to sell the account. Now, for those of you all who have acquired real estate that has still where there's still a mortgage, there is a law. Because my concern was with my dad still having a mortgage. My concern was um, and he had a very low interest rate. My concern was that the bank where he had his mortgage, my concern was that they were going to call in the mortgage. They were going to say, okay, there's $100,000 loan on this property, and so if now you have inherited the property, now you're going to have to take over this mortgage, which I wouldn't have actually had an issue with if I could get the mortgage for the same interest rate that my dad had it. But my concern was that they would call the loan in, or they wouldn't give me the same interest rate that he had. And I'd have to like refinance. And during that particular time, interest rates were high. But there's a law that is called it's a 1982 Saint um, Germain Act, which is an act that protects beneficiaries for people who inherit a home with a mortgage. It protects them from the mortgage lender taking advantage of them. And so what we did was we sent a letter to the mortgage company citing this act and letting them know that our intent was to continue with the mortgage payment, and that we had inherited the property. And basically what they did was they accepted it, acknowledged it, and sent us a letter back identifying my brother and I as successors. They were like successors to the loan. And then that basically protected us from them calling in the loan. And we were able to then continue to pay the mortgage until we could sell the house. And so that took a huge load off of us, because we were not really sure what we were going to do with that house. We still didn't know whether or not we were going to sell the house, or we were going to try to keep the house. And but the other thing that was, I think, one of the more confusing things on that form, on that inventory form, is the section. I think it's part 1 and part 2, and the question is whether or not you're going to need to sell the house, I guess, in order um, to cover debts. Denise, did you want to say something?
No, I'm listening to you. Go ahead.
Yeah, in order to cover debts. That was a huge stumbling block for us, because we could not figure out for the life of us whether or not we needed to put that in part 1 or part 2. And at that particular time, I called Denise and we talked about it. And because my dad had no other debts, and we did not necessarily need to sell the house in order to settle any debts, we put it in part 2, which was property that could be added to the inventory in order to settle debts if you needed to. So we proceeded on with that. So again, to get back to the notice of the creditors, we issued all the notice to the creditors. In our particular case, my dad didn't have any, he didn't have any creditors. All he had was the mortgage. So That was pretty clean. So we came back like 90 days after the letter of administration was issued. We came back to them and brought the form, which is called it's called an affidavit, the affidavit of notice to creditors, which is the AOCE 307. We brought that in, um, along with proof that we had issued notice to creditors in the newspaper, and they were able to sign off on that. At the same time, and that within that 90-day period, we brought the basically the next inventory sheet, and then we were able to they were able to kind of almost sort of give us kind of reconciliation of it, and we finally closed the account in June. We opened it up in August 1st of 2023 and closed it in June of 2024. And during that period of time, I'd say from November until when we closed the account in June, basically what we were doing from that point was making decisions about what we were going to do with the house. And then and what we decided to do was sell the house to an investor. Once we sold the house, then um, uh, uh, once we sold the house, then we were able to make all the payments from the estate account, of which were basically none. It was just money to be divided between me and my brother. So we were able to send out payments to my brother and I, and then we basically closed the estate account. And then we went back in June for the final inventory, the final annual account and inventory. And at that particular time, we had to report how we actually distributed the money in the estate account. And at that particular time, we also had to provide, bank statements. And I don't know how it is in other counties, but I will tell you that in Cumberland County, we had to provide, I mean, everything. We had to provide bank statements. We had to provide, deposit slips, everything in terms of what we did with that money that went into that estate account, and with that money that came out of that estate account. Even with them, it was interesting because even with them looking at the bank statements, they still want to see deposit slips. We also had at that particular time, we had to provide them with a statement from the funeral home that stated there was a zero balance, anything, any kind of funeral services, um, the burial grounds, all of that. We had to, what they were trying to determine was whether or not we had taken care of all of the affairs of our dad. So once we did all of that, they went over it, and they signed off on the closing of the estate, and they basically told us that everything looked good, but it would be audited, and they would let us know if there were any issues. And so as of now, we haven't heard there were any issues, so we assume that we're good to go.
Mhm. Okay, okay. Wow, that's very interesting. And you know what? I'm glad that we're doing this because I mean I have spoken with several attorneys and no one has ever mentioned to me about the Germain Act. I had
Yeah.
no idea about that.
Yeah.
So how did you come to find out about that?
So actually, the way I found out about it was so a while ago, when my husband and I were moving from Virginia. Actually, we we refinanced our house and put our house in his name,
Mhm.
so that when we moved down here, my credit would be unencumbered, so I could buy a house
Mhm.
in my name. Basically, I mean, we were trying to make sure that we, you know what I'm trying to say.
Yeah.
So anyway, so and how I found out about it was whenever we moved to North Carolina, the house was in my name, and we then refinanced the house again and put it in my husband's name, the mortgage payment. And I called the mortgage company one day to talk to them about the mortgage, and they wouldn't talk to me.
Mm-hmm.
And I was like, but this is my house. They said, we don't care, but the mortgage is in your husband's name. And so I was like, well, what if something should happen to my husband and we
Mm-hmm.
still have a mortgage payment on this house? So how does this kind of work? Do I get to take over his mortgage or, whatever? And then that's when they explained to me, well, it's up to the bank as to whether or not they will let you assume his mortgage at the same interest rate that he has it. And I was
Mm-hmm.
like, really? And so that's when I started researching it on my own. And so when this came up with my dad, you know, I
Mm-hmm.
knew that there was something out there that, that would protect me. So and then and I found this act. Yeah.
Right. So when you presented the information, how did you present this act, to them? What did you say to them?
So what I did was I'm a very direct person. So remember I told you that you're supposed to, if you have known creditors, you're actually supposed, if they have known creditors, you're supposed to actually notify them. So I actually wrote a letter to the mortgage company and
Mm-hmm.
specifically said, we intend to continue to pay the mortgage on this home until we decide whether or not we're going to sell it or not.
Mm-hmm.
And I cited the Germain Act and said, we also acknowledge that based on the Germain Act, you have an obligation to blah, 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 in very legal terms. I was very direct with it.
Wow.
So
Yeah.
I didn't ask them for permission. I just basically said, I know that
Right.
this act exists
Mm-hmm.
and you should allow us to, blah, blah, blah. And so they very quickly sent a letter back and said, yep, you're right. And you and your brother are successors and, you're good to go.
Wow. So how would I get information on that? Do I just Google Jermaine Act?
Yeah. Yeah. You can just Google it. Yep. It's out there. It's out there in the public domain.
Mhm.
Yep.
Yeah, I wish I had known about that earlier because I had a gentleman to call me one day. He called me probably like at 10 o'clock at night, just frantic, that he was afraid that he was gonna lose the house. And he said he had been trying to make payments on his mom's house, who had died, but the bank wouldn't accept payments from him. So it just got behind. And then it got to the point where they finally sent a letter saying that they was going to foreclose on the property. And with his situation, he didn't have the money to pay an attorney. And so he didn't know what to do. And like I said, I wish I had heard about this because I could have, told him about it because they wouldn't accept payments from him. They wouldn't give him any information or anything.
Yeah.
So would a person have to already be the administrator in order to present this act to them?
Yeah, you'd have to be an administrator. You'd have to, well, you not only would you have to be an administrator, but you would also have to be someone who inherited the property.
Right. So it was his mom. He was the
Okay.
only child. So, in North Carolina, that meant the house would just go straight to him.
Right.
But because there was a mortgage on the house, he said he had made several attempts to pay it, but they would never accept. He said that once they found out that she had died, they wouldn't take any payments from him.
So the question that I have is,
Mhm.
was he did he have his letter of administration at that point?
That's the thing. He had not filed he
Yeah.
didn't even know about probate. He
Yeah.
just knew that he needed to make payments, but they wouldn't accept payments from him.
Yeah.
And then once he got the letter that they was going to foreclose on the property, that's when he started looking into it more and he found out about probate. And then he called me up at night,
Yeah.
like
Yeah.
frantic. He didn't know what to do and stuff like that.
So I
So,
think that's probably the issue. There's a difference in inheriting the property and then having the authority to act
mhm,
on behalf of the deceased.
mhm,
And that's probably why they wouldn't accept the payment from him because he didn't actually, even though the property was technically his, he didn't have the authority to operate on
Right.
behalf of the deceased. And unfortunately, um, it so in some cases is to the benefit of these mortgage companies
Mm-hmm.
to,
Mm-hmm.
what I mean, they can take the property and do what they want to do with it. So they're not going to be forthcoming and helpful. And that's why it's important for people to actually do whatever research they can do up front so that,
Yeah.
they can be more forceful in the way that they, approach them.
Yeah. Yeah. So another thing that you had said was about the 60 days that you thought you had 60 days to file, and
Yeah.
they said that wasn't the case. So what were they saying that you can still file after 60 days or
Yeah,
because my
I had constantly seen this. It said,
mm-hmm,
you're supposed to file within 60 days of the person being deceased. Well,
mm-hmm,
that is absolutely not true. And the reason why I know that now
mm-hmm,
is because I have aunts and uncles
mm-hmm,
who inherited property from my grandparents
mm-hmm,
who never probated the property, and my grandmother had been dead since 1986, and so the property just became heir property, and they just were paying taxes on it,
right, yeah,
and
yeah.
they never probated it.
Right, yeah. And what I've been told, I knew you could go longer than 60 days, but what I was told is that 60 days, the first 60 days is like for the immediate family to file. After 60 days, a creditor can come file. Anybody that have an interest can come file. So those first 60 days, if you are a spouse or if you are a child, it's very important that you file then
Yeah.
because you can still file afterwards, but it also opens up that door that
Right.
a creditor or
Right.
someone else can also come in and
Yeah,
file.
that
Mhm.
makes sense.
Yeah.
That
Mhm.
absolutely, I think that's absolutely
Yeah.
correct. Yeah.
Yeah. Yeah. And then so also I was listening when you was talking about with the inventory. So you said that they even wanted to see the deposit slips.
Yeah, the
So
Cumberland County, and but I had talked to someone else in another county that said
mhm.
when they did the final inventory that they really didn't have to present all that
Oh
information,
really?
but we did. I
Yeah.
mean, I just carried like a bag with everything in it,
Right. Yeah.
and so fortunately I had everything, but they want to see everything.
Uh-huh. Did they question anything like for example was furniture or anything like was anything given away? Like I have some people to call me and they'll say, well, the family already came in and took everything. They took the furniture, stuff like that. Did
Hmm.
any situations like that come up?
It didn't. So, and I'm like a really precise, I mean, I'm like overly precise. I mean, sometimes. So when I
Mhm,
started, when we did our initial, um, that initial inventory, and we
mhm,
were asking a lot of questions about, okay, so when we list the furniture, do we need to, have a laundry list, da, da, the probate official looked at me and said,
oh really?
please don't do that.
Mm,
And she said, just give us a ballpark figure of the value of the furniture.
mhm,
So that's basically what we did. We just had like a one liner. But I will tell you what, but I didn't trust that. Honestly, I just didn't. I was a little bit nervous about it. So we listed every single piece of furniture and everything until we knew that my dad didn't have any debts.
mhm,
Then we were like, okay, then we can just kind of put just a global number on here. Yeah.
mhm,
Yeah.
mhm.
And we didn't remove anything
Yeah.
from the house
Mhm.
until after till after we be honest with you, we didn't remove anything in the house until we were getting ready to sell it.
Oh, really? Yeah, yeah. Well, that was smart because, and most people, and I think it's because most people don't know about probate and
Hmm.
until they're in that situation where they have to learn about it. And it's
Hmm.
usually a lot of times it's after they have given everything away or family have come in and
Hmm.
have taken everything.
Yeah.
And from what I've read and what I've heard is that sometime the court will hold the administrator responsible. Like you need to go back and tell the family member to bring that stuff back.
Yeah.
So that's just one thing, if for anybody that's listening to this to keep in mind is not to give away anything, any furniture, clothing, nothing until you're at least out of that notice to creditor period.
Yeah.
So you can decide if you're going to have to sell anything to pay creditors off, or just to keep yourself safe until after that notice to creditor period is over with. But so what would you say was the hardest part or the most complicated part about the probate process?
Um, it's, well, let me put this. It's if it's an emotional, it's an emotional
Mm,
process. I mean, you're trying to grieve your loved one at the same time that you're trying to settle their property. And for me, it was
mhm,
trying to do right by my parents, making sure that I protected their assets, and I made sure that, like, for example, like who's going to get this and who's going to get that. And I was, my brother, and I, honestly, very blessed because my brother and I have a really, really good relationship. And
yeah.
so we were able to really work together,
Mhm,
and there was no bickering, there was no disagreements, it was nothing like that,
yeah,
and
yeah.
so, from that standpoint, it was really, really easy to work with him.
Mhm,
But I think that it was the emotional side of it, but it was also, I feel like, um it's not clear, it's not,
yeah,
it's very difficult to to work through the process because it's just not clear cut, and you can Google stuff online, and one person will say this and somebody else will say that. So that's one of the reasons why when we started out, we actually went to the law. I mean, I have probably a stack of law, the
right.
actual law that the forms were
Mhm,
developed from and the processes were developed from, because I had to get inside my head the intent of the law. And
right,
that is when I started to understand it better, is when
right,
I read the actual law and I was able to get in my head that, well, oh, okay, this is the intent of the law. And
right,
this is why this form looks this way, and this is where, it's trying to
mhm,
go. Yeah.
right,
But if
right.
you just try to operate from the forms without really understanding the intent, you'll just go around in circles.
Yeah, yeah, that's true. That's true. Yeah, well, this has been very helpful, and I'm really glad that you came on to share your experience. I'm not sure if anybody, like I said, has come on, but I hope if somebody does come in the group and later on look at it, that they'll get something from this. I'm pretty sure that they will get something from this. And I know everybody's experience is different, and that's why I'm hoping that more people that's in the group that have completed the process will come forth and share their experience, with it, especially when the heirs don't get along.
Yeah.
Um, I think when the heirs do get along, it's pretty, smooth sailing. But when the heirs aren't getting along, that's probably the time when an attorney does need to be called in. And but the sad thing with that is that sometimes I have spoken with several people who brought an attorney in, and it seemed like the attorney wasn't looking out for their best interest. He
Yeah.
wasn't communicating with them. He wasn't turning in forms. I've just heard all different types of stories and stuff like that, concerning attorneys. But when the family, the heirs just don't see eye to eye, then it's probably in their best interest to bring an attorney in to,
Hmm.
help guide them through the process.
Hmm. Or I don't know, maybe a mediator or something can help, at
Yeah,
least get the
yeah,
relationship, to get them talking or something. Yeah.
yeah, maybe so, maybe so. But anyway, like I said, let me just see if I can check on my tablet just to see if anybody, um, like I said, StreamYard doesn't show me if there's any comments or anything, so um, I can't tell if it is right now. But anyway, hopefully, like I said, they'll go back in and look at this video. This is also going to be on YouTube. So hopefully, I have a lot of people that's starting to find me on YouTube, and they're calling me saying, "Hey, I found your video, and it really helped me." So I'm really hoping that they'll get a chance to see this video, because I think just hearing your journey, your experience, it'll also help somebody out. So again, I just want to say thank you, and I just want to let if anybody does see this video, let you know that I am a realtor. I work with both people, buyers and sellers, but my specialty is probate. So if you're looking for a realtor to help you sell your home, if you have questions about the probate process and you need to sell real estate, feel free to reach out to me. My number is 252-902-9006. So Phyllis, thank you so much for being here. And you can stay on. I'm just going to end this stream, and then we can chat a little bit afterwards, okay?
Okay.
Okay.